Please be seated. We're back on the record in case number 2012 CF 55504A, State of Florida versus William Woodward. We'll note the presence of Mr. Woodward at council table with Mr. Eisenmenger, and Mr. Robinson, and the presence of Mr. Respis and Mr. Shiner on behalf of the state. Mr. Eisenmenger, you wanted to address an issue?
Yes, it is our intention to publish the prior hearing testimony of Bruce Timothy Blake and Kim Stillsbury Cast and Carrie Blake. I didn't know whether the state is going to object to that. We have some legal arguments. I wanted to give them a heads up and so we could argue that issue if it is an issue outside the presence of the jury. Mr. Eisenmenger will handle our argument.
Well, this is the first I'm hearing about that, number one. And unless it meets an exception to hearsay, it would be hearsay. The only hearsay exception I know of for former testimony is former testimony, and that would require unavailability, which I don't think exists. So that's my position of it. So we're not agreeing unless there's some they become unavailable.
Right, so just so I'm clear, the three witnesses are Bruce Blake,
Yes.
Carrie Blake,
Yes.
and
Kim Cast.
Kim Cast Stillsbury, I believe, as she testified during the state's case, and Christopher Eisenmenger for the record. Your Honor, we would be seeking to introduce this under 803.22, which is an exception to the hearsay rule where the declarant's availability is immaterial. That 803.22 contemplates former testimony given by the declarant, which testimony was given as a witness at another hearing of the same or a different proceeding, or in a deposition taken in compliance with the law in the course of the same or another proceeding, if the party against whom the testimony is now offered, or in a civil action or proceeding, a predecessor in interest, or a person with a similar interest, had an opportunity and similar motive to develop the testimony by direct, cross, or redirect examination, provided, however, the court finds that the testimony is not inadmissible pursuant to 402 and 403, which is, of course, how the rules of evidence operate in any event. It is our position that the stand your ground hearing previously conducted afforded the state the opportunity to develop similar motive, or gave them a similar motive to develop the testimony by cross-examination of Bruce Timothy Blake, because he was called actually by the defense in that hearing, and the other witnesses. I don't recall, I believe they were defense witnesses as well, but they may have been state witnesses. In any event, the state would have had either the opportunity to develop a direct examination or a cross-examination of those witnesses at that hearing. And therefore, that former testimony, again, under 803.22, where the declarant, the availability of the declarant is immaterial, would be admissible as an exception to the hearsay rule. I have a couple of cases to provide to the court in that regard. I may approach.
you may.
Your Honor, the first case that I'm providing the court is Alvarez v. Crosby, which is a 3rd District Court of Appeal case found at 907 Southern 2nd, 1231, and it's from July of 2005. In the Alvarez case, they were dealing with an issue of post-conviction relief for a failure of appellate counsel to raise an issue about the exclusion of some proffered testimony at a prior trial. The court ultimately granted post-conviction relief in that case. Interestingly enough, during that procedural time, the state had filed a motion to relinquish jurisdiction, which is referenced on page 3 of my printout, what would constitute 1234 of the record on appeal. The court looks to the right-hand column, the second full paragraph, the third paragraph on the right. It said the state had filed a motion to relinquish jurisdiction. The state says that recently witness Perez, the witness that had given the proffered testimony, has, quote, given the state a sworn statement indicating that she has no recollection of the matters proffered to the trial court. The state argues that as she has no recollection of these matters, the defense will not be able to present Ms. Perez as a witness at a new trial, and therefore reversal would serve no purpose. The state requests a relinquishment of jurisdiction to have the trial court take Perez's testimony to determine what her live testimony would be in the event of a new trial. I think that's particularly important procedurally as we stand in this case, especially as it relates to Bruce Timothy Blake, as Mr. Blake claimed a lack of recollection for a number of things, not only that happened the day of the event, but also as to what he said at the stand your ground hearing. The court continues in the Alvarez opinion. We deny the state's motion. The state has not cited authority for the proposition that this court may decline to correct a harmful trial error on the theory that a witness may be uncooperative or claim a lack of memory at the time of the retrial. The only case cited by the state is State v. Robbins, 1B ROBINS, found at 484 Southern 2nd 877, which is the Louisiana Court of Appeals case from 1986. And they say in that case, the Louisiana court allowed a relinquishment of jurisdiction to permit a proffer of evidence which had been excluded. Louisiana counsel had not made a proffer at the time the evidence was excluded. They continue. Florida procedure on this point differs from that of Louisiana. Under the Florida Evidence Code, a proffer is to be made in the trial when the evidence is excluded. See Rule of Evidence 104.1b. The Louisiana case thus addresses a situation which is not applicable here. Further, in the present case, trial counsel made the proffer by taking the testimony of witness Perez under oath outside the presence of the jury. Although the parties have not addressed this issue, it appears that this proffer qualifies as former testimony under oath, which can be introduced by the defendant under subsection 9803.22, and then it cites to Earhart on evidence, Your Honor. And that's exactly what we're trying to do here, because the state did have, at that stand your ground hearing, the opportunity to develop that witness's testimony. The issues are virtually identical as they would be in the defense's case in chief. Second case that I have, Your Honor, if I may approach.
You may.
That is the case of Johnson v. State, a 3rd District Court of Appeal case found at 47 Southern 3rd 941 from November of 2010. In this case, the defense attempted to introduce former testimony by a witness as to whether or not the defendant was acting in self-defense. Turning to page 2 of my printout, which would constitute 943 of the record, what begins designated headnote 3. Here, Vega's testimony was relevant to an issue in dispute, to whether the defendant acted in self-defense. To determine if the defendant acted in self-defense, the jury was entitled to hear everything that occurred prior to the shooting, including who brought the gun. The jury could reasonably infer that the person who brought the gun was likely the aggressor. Without Vega's testimony, the jury only had the testimony of the victim's employee, which suggested that the defendant brought the gun. Thus, Vega's testimony that she had the gun and showed it to the victim prior to the shooting was clearly important. State argues that Vega's testimony would only have confused the jury because she also testified that she saw the defendant with the gun at the time of the shooting. The fact that at some point the defendant had the gun in his hand does not conclusively disprove the defendant's claim, that he was not the initial aggressor. Thus, Vega's testimony was highly relevant under 402. Typically, juries are presented with different versions of events and must be trusted to consider and weigh all the evidence and to ascertain credibility. Here, the trial court abused its discretion when it excluded Vega's prior testimony simply because it contradicted the other evidence. Again, in that case, the defense had sought to introduce Vega's prior testimony under 803.22, which if I... Your Honor, I'm sorry, I started too soon. It's the paragraph just before where I started. It says, moreover, all relevant evidence is admissible unless excluded by law, which is 9402. Section 9803.22 of Florida statutes allows introduction of former testimony, notwithstanding a witness's availability, as long as the witness was subject to direct, cross, and redirect examination. Conversely, evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice, confusion of issues, misleading the jury, or needless presentation of cumulative evidence, that of course being the 403 balancing test. I would note, Your Honor, just so our position is clear, that the Florida Supreme Court
You may.
when this amendment went into effect in 2000, the Florida Supreme Court did decline to adopt the amendment to the extent that it was procedural concerning, and I've provided the court, I'm sorry, with a copy of the in re amendments to the Florida Evidence Code, Supreme Court number 00-607, which can be found in 782 Southern 2nd 339. It's from October 26th of 2000. They declined to adopt it to the extent that it was procedural, but they left at issue the procedural substantive interplay of this particular rule of evidence, waiting for a case at controversy. So they didn't say that it's unconstitutional. They simply declined to adopt it, waiting for a case in controversy. And what I would suggest to the court in applying it in this fashion, there is no constitutional issue because the state doesn't have constitutional rights at a jury trial. The defense has constitutional rights at the jury trial. And that's where 802.22 can cause some troubles with admission of prior testimony. That's why depositions in a criminal case are not automatically admissible against the accused, because we have an issue with confrontation, a constitutional right to confrontation. This does not violate the state's procedural rights because the witnesses are now claiming no recollection of the event, and the state had the prior opportunity to develop their cross-examination when they did recall these incidents at the Stand Your Ground hearing. Any procedural impetus this may have on the state attorney's office should be resolved in favor of the defendant because he has a due process right to present a defense to elicit this testimony before the jury. And as we've already seen from Bruce Timothy Blake, he's not willing to acknowledge recollection of that, and there is no other way for us to offer his testimony. The same is true for some of what we've already seen from Kim Salisbury, or Cass Salisbury, and we anticipate the same from Carrie Blake. So the court should allow us at this time to introduce the prior sworn testimony by way of the transcript. And procedurally, Your Honor, we would be seeking for law school asked and answered, for lack of a better term, where we would have one person on the stand reading from the transcript and Mr. Eisenmenger reading the questions that were asked. And we would direct the court and opposing counsel to the various portions that we intend to publish throughout the document. But especially in Bruce Timothy Blake, he acknowledges some statements that he did not acknowledge during this trial. He acknowledges hearing some of those things after his recollection has been refreshed with the video. There is a clear question and answer of who said this, and he would say, either I said that, or another witness said that, or I heard it, but I don't know who said it. And we believe all of this evidence would be relevant and admissible in today's proceeding. Thank you.
Mr. Eisenmenger, are you seeking to introduce by way of the transcripts the entire testimony of all three of these witnesses during that prior court proceeding?
No, I don't believe that that would be necessary. If the state had some sort of objection as to rule of completeness, we could certainly deal with it at that time, and I think the state would be free to publish additional portions of that same testimony if they felt that it explained the witness's testimony. But what we've done is we've gone through and we've identified a number of different places where there's a clear acknowledgement of a statement and then attributing that statement to either the witness himself, Mr. Blake, another party, or hearing it, but nevertheless not being able to attribute it to any person. I think in all three of those situations it'd be relevant and admissible because he acknowledges the statement in some fashion and then discusses who made the statement that night.
And I'm not sure if it has a bearing on the issue, but as far as these three individual witnesses, were they called by defense? Were they called by the state at that hearing?
Both Carrie Blake and Bruce Timothy Blake were called by the defense. I'm looking through. It was my memory that Kim Cass was called as well, I thought by the defense, but I'm trying to locate her transcript. It is a possibility that I've confused her with a different witness in my mind, perhaps Jessica Nobles. So Kim Cass may not fall in this category, and I apologize for the confusion there. But certainly Tim Blake, Bruce Timothy Blake, and Carrie Blake were called by the defense in that hearing and cross-examined by the state.
Okay, so the defense still needs to confirm if there is a third potential witness by way of transcript, if the court allows this former testimony, if it's Kim Cass or another witness, or?
No, and Kim Cass may not be available to call in this fashion. I may have to call her back live, is what I'm informing the court. I had this huge transcript thing, and I was looking for her testimony. I definitely have. But she did testify. I take that back. Just isn't in my book here. So yes, it would be all three.
And was she called by defense or the state?
Let me look. Oh, I'm sorry. It would be her injunction testimony that's been handed to me. And she was called by the court in the injunction testimony.
But we weren't a party to
Yeah,
that.
they were not a party to that.
Okay.
So I go back to my original position.
So we're just talking about Mr. Bruce Blake and Miss Carrie Blake.
Yes, Your Honor.
Yeah.
That'd be correct. Thank you. Nothing further.
Thank you. State's response?
None of the cases they cite deal with the situation where the witness actually testifies in the trial, because this is changing the context of the testimony. This is being used in lieu of a witness testifying, number one. Number two, there's a case, and there may be a difference because, but there's a case called Gray Bob versus Department of Health, Board of Psychology, 816 Southern 2nd, 701. And I'm relying on Earhart because I didn't know we were going to be addressing this issue, that held that this was unconstitutional. This particular provision was unconstitutional based on separation of powers. So I don't know what the status of that, how that impacts the ruling. That was a civil case, and I guess both parties could be procedurally prejudiced, and maybe there's an argument that we couldn't be, but at least in that context, the statute, as I understand it, was determined, that portion of the statute was determined to be unconstitutional. So I wanted to start there. Secondly, when we're dealing with Bruce Blake was confronted with the transcript, asked if he said those things, admitted he said those things. Those things are before the jury, and if they didn't ask him, then they can call him again and ask him. But I don't believe it's appropriate to parse out portions of testimony through the mechanism that they're describing. I think that that's being offered as a form of impeachment. It's improper impeachment is what it amounts to. And so I think I caution the court to go there with that. As to Carrie Blake, she's not been called at this point. But I do believe if they're going to do it, they need to do all of it, so that there's context. Because the whole point of this is that there's a meaningful opportunity for both sides. Frankly, it would be better if they have it in a video format so that the jury can see how the witness is reacting to the questions rather than on a cold transcript where the person acting as the witness wasn't even present for the hearing. So those are the concerns that I have about this. Number one, whether or not this is even a constitutional provision or not. Number two, I think the way they're using it against Mr. Blake would be improper impeachment. And I object to them if they have another means to prevent. If you're going to allow it, I would ask it be done as close to live testimony as possible.
Do you have a copy of the case that you cited, Mr. Respos?
The case that I cited, it was in Earhart. I think they're going to. He's printing it. The Graybow case.
So you do or do not have a copy?
I'm printing it right now, Judge. I didn't want to.
Okay.
Your Honor, if I found the case that he's talking about, the site is 816 Southern 2nd, 701.
I have the site.
Just first DCA 2002. I just wanted to make that clear for the record.
All right, anything further from the state?
I'd like to have a little bit more time to look at this, but that's what I've been able to give you in the amount of time I've had to deal with the issue.
May I have the attorney's attention for a moment, please?
Your Honor, in responding to the state's argument regarding the first DCA case, the civil case that they cited, if the court finds that to be controlling over a criminal case, one, at the very least we'd have a conflict in the DCAs because we'd have the first DCA from 2002 and then subsequent opinions from the third DCA twice suggesting that this is a proper procedure in a criminal case. I'm not aware of any binding authority in the fifth DCA, so I believe the court would be free to follow whichever of the DCAs it wants. Again, assuming that the first DCA case even applies to our case, statutes constitutionally, the court should attempt to resolve every statute as if it is constitutional. And it's only as a last resort should the court declare a statute unconstitutional. And it's our contention that this statute can be applied constitutionally in this situation given the procedural facts that we have in response. And so that would be the defense's argument as to why the first DCA case is first inapplicable, but two, even if the court finds it's applicable, the court's still not bound to follow it.
Okay, thank you. Mr. Shiner, do you have a copy of the case? You may approach. Or a copy to defense, please. All right, as far as that issue then, I've heard the arguments. I know the state hasn't had a whole lot of time to respond to the request made by defense. If you all wish to readdress it and have further case law, I'm going to reserve ruling at this time and allow the defense to proceed. All right, is there anything else we need to address before we bring the jury back in and allow the state to announce that they've rested and allow the defense to proceed? All right, let's go ahead and then bring the jury back in, and then the state can announce that they've rested and we'll allow the defense to proceed. Please be seated. Jury is present in the courtroom again, and ladies and gentlemen, did you follow all of my instructions during our lunch recess? Yes. Is anyone aware of any violations of any of my instructions? No. All right, and sorry for the delay in getting started this afternoon, but at this time, how would the state like to proceed? How would the defense like to proceed?
Call our first witness, William Francis Woodward.
William Woodward. Thank you. William Woodward, please. Good afternoon, sir. If you'd please step to the podium. Please raise your right hand to be sworn in. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor, I do.
Please have a seat over here on the witness stand. And if you would please state your full name.
William Francis Woodward III.
You may proceed.
All right, thank you. Mr. Woodward, let me start with, what is your relationship to the defendant, William Theodore Woodward?
A little softer, please. It's coming a little loud. Can you turn it down a little bit?
Can I turn it down? Are you having trouble hearing me, sir?
No, I can hear you fine. I'm
Okay.
just
Mr. Woodward has an implant, and there's sometimes resonance from the
electronic.
court system.
Okay.
Let me see if I can
There we go.
avoid amplification with that and speak loud enough so that you and the jury can hear.
I can hear that just perfect.
Perfect.
Okay.
Sir, could you state your relationship to William Theodore Woodward?
He is my oldest son.
Mr. Woodward, could you briefly tell the jury a little bit about your background and experience?
Well, when I got out of high school, I was doing construction work and went off to New York to work for a highway department up there, and decided while I was up there that I wanted to go into police work. Came back to Titusville, Florida, and started with the Titusville Police Department in 1972. After breaking my back in 2 places in 1977, a doctor thought it was a good idea to get out of that line of work, and I did. I went out to Kennedy Space Center in security, and after managing their law enforcement section for a couple of 3 years, I went over, transferred over to operations as a test conductor on a firing room console. And then I went back out in the field as a buried utility locator, requiring electrical engineer, or not electrical engineering, but industrial electricity in order to be familiar with the operation of the equipment. Got laid off in 2008, and I went back to work for County Property Appraiser's Office in 2009 as a fraud investigator in homestead exemption, and I worked there until August of 2015. 2015, I think. Yeah.
Throughout the time that you were a Titusville police officer, you continued to be certified as a law enforcement officer.
Yes, sir. I had full state certification to be a uniformed police officer, plainclothes police officer with full arrest authority.
Now, Mr. Woodward, particularly during the time that you were an officer with the Titusville Police Department, what was William Woodward's age, and was he living in that household?
He was living in our household. He was born in 68, 72. He was 4. He was 4 years old, and when I left the PD another 8 years later, he was 12, 13.
Now, as part of his upbringing, and you as a police officer, did you raise him to cooperate with law enforcement?
Yes, sir, I did.
Now, I want to move you up a little bit to the events of 2012, and more particularly, the events around August 5th, 2012. Do you recall that time period?
Yes, sir, I do.
Okay. Did there come a point in time when a dispute began between the Embreys, Picciors, the Blakes, and their significant others, and your son and his family?
Yes, sir.
Were you actually part of that dispute in terms of actions taken against you and your wife?
Yes, sir, I became part of that. About 1 o'clock on August the 5th, 1 p.m., when my daughter-in-law called me and said, "Bill, can you get over here? Something bad's happening."
Let me stop for a moment. You told us 1 p.m., but you didn't tell us the date.
August the 5th.
Okay, so you actually got called into it as early as August the 5th. Is that correct?
That's correct.
Okay. Now, I don't want you to repeat what someone else told you. They
Right.
may be testifying, they'll fill it in. But as a result of that telephone call, did you actually go over to your son's house?
Yes, I did.
Could you describe to the jury what you saw when you got there?
I arrived about 3 or 4 minutes after Barbara called me. We lived just around the block. And when I pulled up, stopped my truck, and I observed my son sitting on the north side of Smith Lane in a driveway of a vacant house. He was sitting on a lawn chair. And on the other side of the road, in the yard, right up against the sidewalk, what looked to be about 10 people or more. And when I got out, they were all yelling and screaming, and my son said a few things. And at that point, I walked over to my son, and I said, "Son, are you okay?" And he said, "Yeah, Dad." He said, "I'm not doing too bad."
Again, don't repeat what someone else said.
Right.
Just what you did or what you observed.
Objection is sustained. You may continue, sir.
I asked him if he was all right. I then was told a few minutes later,
Objection, telling him.
I'm not absolutely sure because it may depend on who told him and what it was. But again, I don't want you, if you can avoid talking about what other people said, put it more in the context of what you observed.
okay.
I would appreciate that. That's what we want to share with the jury.
Okay, what I observed was the people on the other side of the road and my son on one side of the road, and that was what I observed.
Okay. Now, the nature of the comments that were being directed against your son, generally, did they concern you?
Yes, they did.
What were your concerns after hearing these comments directed toward your son?
The comments were very vicious in nature. They were violent. They were just things that had been a long time since I'd heard any kind of thing like that before. I didn't know some of these words that I was hearing, and I hadn't been familiar with them for years. But they were just very violent, talking about all kinds of different weapons and stuff, and that's what I remember from that.
Okay. Now, as a result of hearing these violent comments and these different statements, did you have any concern for your son's safety, your daughter-in-law's safety, or your grandchildren's safety?
Yes, sir, I did. I had concern for all of them's safety. As it stood, my son was far outnumbered, and his daughter and his son and his wife were not that far away. Something could have happened, and we could have lost all of them, it appeared to me.
Okay. Now, after the 5th, did there come a point in time where you saw similar conduct like this directed toward your son and his family?
Yes, sir.
When was that you personally observed?
A couple of days after the 5th, we had a good rain shower, and the rain had washed some sand away from the area between his sidewalk and the gutter at his house. And we went over there to see if they were okay. I went and got a shovel and went down by the street and started shoveling the sand back up on the area between the sidewalk and the gutter. I didn't want my son down there because there were already 2 or 3 of the adults down by the sidewalk on that side of the road. And they were kind of taunting and yelling, like, "Come on over here and let's see what we got," and things like that. And I was close enough to hear that. And at one point, Roger Pecor came across the yard to the area right around the sidewalk and yelled, I need to cave that old man's head in. I just think I'll cave it in. And
Speaking about you,
Sir?
you take it as directed toward you?
I was the only one there, yes, it was sitting at me. He was looking straight at me. So I stopped what I was doing with the shovel, and I held the shovel and I faced him. Because I thought if this is going to be a confrontation, I don't need to be turning my back on him.
Now, let me stop you for a moment.
Okay.
What is your age at this time?
5.5 years ago, 64, 65,
Okay. Your height and weight about that time?
about 215, 220.
Okay. How tall are you?
Right now I'm 5'11".
Shrinking?
Yeah.
I'm experiencing that as well. All right,
Yeah, I came down from 6'2".
okay. In turn, Mr. Pecor was significantly taller than you, correct? Yes, no? You have to
Yes.
answer out loud.
Yes, sir.
Significantly heavier than you.
Sustained.
What would you estimate Mr. Pecor's height and weight as?
He looked to be about 6'3", 6'4", and probably 250, 260 pounds.
Okay. Did you have any concerns for your own personal safety as a result of Mr. Pecor's comments directed toward you?
Yes, I did.
And what were those concerns? Please tell the jury.
Concerns were that I was not only,
Objection, relevance.
Overruled. You can answer.
Go ahead, sir.
my concerns were not only that I was underweight compared to him and I was shorter, I was also quite a bit older, and I had suffered a broken leg in 2011. And of course, my broken two vertebrae in my back in 1977. And I've had 2 hernias replaced and 2 knee operations, so I didn't feel like it was going to be a very equal contest, but I was willing to protect my son.
Now, was your son in a position where he was able to observe and hear these threats directed toward you?
I don't know where my son was at that moment. I don't know if he was standing up in the yard. I wouldn't watch him back there. I was simply watching across the street to see if I was going to have to move quickly or do something else.
Did there come a point in time between when this happened, around August 7th or so,
Yes, sir.
and September 2nd on into the early morning hours of the 3rd, that you and your son had discussed this incident so that you knew from your own personal experience he was aware of what had been done to you?
Yes, sir. There was one other incident that happened.
But we'll get to that in a moment. I want to talk about this one in particular. Did you discuss this one with your son? Did he know about it? Was it part of his consciousness on September 2nd?
Yes, sir, he did.
Okay. And you had shared your concerns and your fears on that day with him at a later time, at least?
Yes, sir.
Now, you were about to tell the jury about a second incident directed at you. Is that correct?
I'm sorry.
Were you about to tell the jury about a second incident directed specifically at you?
Yes, sir, I was.
What is the date of that?
That would be about the 18th on a Saturday evening
Of August?
of August. Yes, sir.
Okay, I want you to hold up on that one for a moment,
Okay.
because I want to get a little bit of a chronology going here. Were you part of or subsequently learned of an incident where your son was falsely accused of having a gun?
Yes, sir. That was on Sunday the 5th
Okay.
of August.
Now, as a result of that particular accusation, did that cause you and your son to do anything in terms of being able to have a record for the future because of this false accusation?
Not quite. I know what we did, but I'm not quite sure if that's the answer you're looking for.
Well, I'm not really looking for any answer in particular. I'm looking for what happened. But specifically, I'm referring to the security camera. As a result of that incident, did you all purchase and install a security camera?
Oh, yes, sir. Yes, sir. In fact, that evening after the incident settled down on September the 5th, that afternoon, I left about 4 o'clock from my son's house and went home, got cleaned up. My wife and I went down to Radio Shack at the suggestion of Sergeant Thomas House with the Titusville Police Department. He said, "Why don't you install a security system?" We will do that. So we went down and purchased a security camera that had night vision, the daytime vision. It also had audio. It could record audio up to a certain number of feet away. And we purchased that, took it back home, and installed it.
Okay, let me talk about the installation of that for a moment. Where did you install it? on your son's house? What was the location you all decided was best?
The front of my son's house faces a little bit northwest. We installed it under the eave on the northeast corner of the house. We installed it so that it was looking, sir?
Go ahead. Tell them
Okay.
why you installed
We
it.
installed it so that the left side of the camera picture was along the northwest corner of the house. And then there were a certain number of degrees that the camera would seek on the, from that line over to the right side. And we installed it so that it was covering his front yard.
Okay. Now, why did you pick that particular view instead of the front of the house?
Because most of the activity was occurring in the front yards,
When you say activity, activity involving who?
involving the Hembrys, the Cores, Blakes, the children, all of the two addresses over there across the street.
Okay. So was the camera pointed towards those residents in particular?
Not those two residents. It was more focused on Billy's residence, but in the way we had it set for Billy's front yard, it was taken in from the vacant house across the corner to Gary Hembry's house.
Okay. Now, specifically,
You may.
I want to show you what's been marked as Defendant's Exhibit A. You recognize that particular flash drive?
Yes, sir, I do. It has my signature on it, and I'm the one that put it there.
Okay. Now, did you view there's two clips on that particular flash drive, is that correct? A clip from August 11, 2012, and a longer clip from September 2nd through the 3rd.
Yes, sir.
Did you view those?
Yes, sir, I
Are they
did.
true and correct copies of the video surveillance that from the camera you installed and a copy of what had been turned over to the police?
Yes, sir. These scenes and the words on here are the identical ones that were on the original hard drive that I copied to blank hard drives to give Mr. Eisenberger one, the state one, and I think you had an extra one, but I'm not sure. But I did the copy. Those same scenes are on this one. They haven't been changed anyway.
Okay. This particular version has not been enhanced or brightened up by anybody. This is actually the raw footage from the camera. Is that correct?
That's correct. There's
Okay.
not
You
been.
you viewed all of those, and they're true and correct and complete.
Yes, sir, I
I
did.
would offer Defendant's Exhibit
You have the attorney's approach. All right. Without objection, then, it'll be introduced as defense one in evidence.
Okay. We'll probably get around to playing some of those clips a little later. But now I want to talk about the times that you were actually there and personally observed conduct directed either at you, your wife, your son, your son's wife, your grandchildren. Okay? So we'll start and try and take it more or less in chronological order and have you tell the jury about conduct that you personally observed. Okay? We're past the 5th now, past, I think, the 7th or 8th. There are other times where you personally observed things directed at one of those groups of people by either the Corps, Hembry, Blake, Cass, Daniel, or I think those are all the players, or their children.
You're asking about an incident that involved all of us together witnessing?
I'm talking about things that you observed with the gang directed towards your son's family or you.
Okay. I'm not sure if it was, I think it was August the 18th, the Saturday afternoon. My son called me, we were out eating, and wondered,
Repeat what somebody else said, just what you did and you observed.
well, I'm starting from the point when I observed it, when I
All right.
started observing. Asked me if we could come by the house. He said, somebody's called the police. I said, okay. So we went there. And when I got to his house, I observed 2 police cars in the area. I observed my son standing out in his yard, and I observed all of the 6 adults and 6 or 8 children over to the other side, on the other, across the street. The police officers were talking to them across the street at that time, and I walked up in the yard, said hello to my son. A few minutes later, one of the police officers came over and came up in the front yard with where Billy and I were standing.
Then talk about with somebody else.
Right.
So,
And then,
there's some conversation with the police officer.
yes, there was conversation with the police
I
officer.
want you to repeat that. I'll try and address some of that later. But after that conversation, were any arrests done or any action at all taken by the Titusville Police Department to protect your son and his family?
No, sir.
Now, after the police officer left on that occasion, did that calm down the situation? Did the activity of the people across the street diminish?
No, sir. Did
What
not.
actually happened after the law enforcement left?
After the officers left, there was no diminish in the activity across the street.
Well, I mean, describe to the jury the type of activity that was directed toward your son's family and you, even after the police had been there and talked to everybody.
There were numerous taunts. There were threats by the adults to take golf clubs, to use bats, machetes. There was a big jumble of noise over there, and you could pick out those particular words, among others.
And how long did it take them from the time the police got out of sight to start this behavior back up?
I would say they didn't even get around the corner of Smith Avenue, the west corner of Smith Avenue, and they started back up again.
From your own personal observation, did the presence of the police or the intervention of the police have any effect on the people across the street, or did it just embolden them?
None, sir. I observed Rusher Bakur throw his hand up in the air, point, and then I observed a police officer get in the car and leave. I don't know what that meant, but that's what I observed at that moment.
Okay? And then, as you already testified, almost immediately later, they started back with the taunting, insults, shouting, etc.
Yes, sir, that's correct.
Now, this conduct that you observed on that particular day, was that unusual conduct by them against your son?
Object unless it's from personal knowledge. He's indicated he's had 2 incidents.
I will lay that, include that. I'm
Sustain.
talking about all these things, I'm talking about things that you personally observed, okay?
Yes, sir.
You personally observed it, that's the category. If I forget to add in from your personal observation, I want you to understand, I don't want anything that you heard from anybody else or talked about with anybody else. I want to talk about things that you personally observed.
Okay.
Okay? Based on your personal observation, with this kind of conduct that was directed against your son and his family by the Poor, Hembry, Blake ensemble, unusual.
Yes, it was unusual. Yes, sir.
Okay, what was unusual about it?
It was unusual. It was unusual because I had really never witnessed this type of activity or group mentality of this nature at anybody in my law enforcement days, and I was using that as a standard. And I had not seen that kind of behavior before.
Okay?
I was amazed.
And perhaps I did a bad job of asking the question. Was this an infrequent occurrence of conduct like that, from your observation?
It was not infrequent during that time period.
Okay. Were there other occasions that you recall specifically that you were personally around where your son and his family were subjected to this kind of behavior?
I can't think right offhand of, with the exception of that afternoon in the yard. There was one evening I went over and was walking with my son and his dog
Tell the jury about that.
before he turned in. In fact, I made a habit of going over every evening and walking with him so that he could walk his dog and then turn in. We were walking east on Smith Avenue. Smith Avenue makes a U-shape, a circle. We were coming back up the west side, on the north side, going west, and Gary Hembry approached from the cross section, and he had another young man with him, and he was walking one of his dogs. I told Billy, let's go, let's just keep on walking, and we did, and I thought maybe if they don't stop, we need to turn around and go back. But they did stop, and they stopped just right on the edge of the intersection. And we went and crossed the intersection and went on about our business and went to his house. There was one other one. We were finishing a walk one night.
Well, before you jump to another one, I want to stay on that one. You said Gary Hembry came up. Did he do anything other than just come up and watch you all on that particular occasion?
Yeah, that's all he did, yes, sir.
Okay.
He walked towards us and then stopped. So we
Okay.
kept walking.
All right. So nothing in terms of the exchange of threats or anything occurred on that.
No.
Okay. You were about to tell us about there was something struck your memory?
Yes, sir. It was either Monday evening, Monday the 6th in the evening, or Tuesday the 7th. In the evening, I went over again to walk with my son while he was walking his dog. And as we finished the loop around Smith Avenue,
Objection, can we get a more accurate date as to month because we've gone from the 5th to the 7th, and I just want to make sure we're talking about what month we're talking about, what day.
Okay. Well, are we talking about something that occurred in August 2012?
yes, sir, I apologize. It was August the 6th in the evening after dark, or August the 7th in the evening after dark.
Okay.
We were about to finish our walk, came around the corner. We were passing on the north side of Gary Hembry's house, on the north side of the street, away from his house. And I could see Gary Hembry standing out in the moonlight under one of the trees. And as we got towards the intersection, I observed Roger come running across, and he had his arm up, and he was waving his arm, and I couldn't see what was in his hand. As he came running towards the sidewalk, I turned around to face him in case he was going to come and do something, which I didn't know at that time. I had no idea. And at the sidewalk again, Roger stopped, and then I could see that he didn't have anything in his hand. It was just his fist he was holding up. So I felt no fear at that time. I felt no threat. So I turned around, and my son and I kept walking to his house.
Okay. Well, did he say or do anything other than this approaching you that verbalized anything?
Yes, he did. Thank you. I heard him say that he was going to, I need to take a bat to the old man's head.
Okay. But the fact that he didn't have a bat at that moment
Didn't bother me at that time.
Is that correct?
Right.
Okay. Now, did you ever observe anything in terms of one of these people's dogs? And
I didn't personally observe it, but I viewed it on the videos.
okay. As a result of viewing on the video, did you have concerns about the use of the dogs as a weapon against your son?
Absolutely, yes, sir.
Now, the police were called on that occasion, is that correct?
They were called that evening, yes.
Okay. And did you personally have any conversation with the law enforcement officers regarding what you had viewed on the video, and in terms of asking them to view it on the video?
Yes, I did.
Could you tell the jury about that conversation from your point of view?
I told the officer that, in my view, not only from my law enforcement days, but it's the same today, that the dog issue is an aggravated assault. It's a felony, and a person can be arrested without having the officer present. And I offered the videos. I said, can we make you a copy of the tape? Can you come in and look at the video? We haven't changed anything. We make you a copy of it.
Did the officer accept that offer?
No, she did
Did the
not. She
officer
said,
make any arrest or take any action to
No, sir.
protect your son and your family?
no, sir, not that evening.
Now, again, is this something that your son was aware of, this interaction? I think he was personally, from your testimony, he was personally involved in that. But were your concerns and your belief that those actions constituted crime shared with your son?
Yes, sir, I did. I shared that with him.
Okay. So that was part of his thought process on September 2nd through the 3rd.
Yes, sir. And he was standing there with the officer and I when I did that.
Okay. Now, were you personally frustrated by the lack of response that Titusville Police Department was offering? For
Very frustrated, yes, sir.
Why?
Extremely. I guess because in my experience, we had instances similar to this back in the days that I wore the uniform, and we were able to fix them. We were able to make them go away, however you want to call it. We were able to get them settled down. We were able to get the people back on track again, using common sense, if nothing else, and maybe some suggestions. But I'd never seen one allowed to go this far, allowed to go for 27 days.
From your personal observation, did the Titusville Police Department take any action that you deemed was protective of your son or your family?
In my personal observation, no, sir.
Now, you've testified that that was a source of frustration and concern for you. Did you have discussions with your son where you expressed those concerns?
Yes, I did, sir.
Okay. So that was part of his thought process as well.
Oh,
Your concerns about the police response and their ability to protect your family, that was part of his thought process as well.
yes, sir, that's correct. Yes, sir, that's correct.
Objection, speculative.
Laid the predicate for it.
Overruled.
Okay. Now, we've already had some testimony. I won't go into a whole lot with you, but you were also there. You had actually filed an injunction based on the actions against you as well. Is that?
I'm sorry, sir, I didn't quite follow that one. A little slower.
Listen to the injunction. You had filed
Okay.
an injunction for protection, asking for protection for you and your wife against part of the Picayune, Embry, Blake group. Is that correct?
That's correct, sir.
And your injunction was called up, I won't say heard, but was called up the same day as your son's injunction, your daughter-in-law's injunction, and the Embry, Picayune, Blake injunction. Is that correct?
That's correct, sir.
Now, again, we've heard some testimony, but were you allowed to actually present any evidence in support of your injunction on that day?
I was allowed to speak before the judge with Mr. Pecor president. That was my injunction was against him for coming across the yard the day it
I
rained.
understand you were allowed to speak. My question was, did the judge allow you to actually present any witnesses or any of your supporting evidence?
Oh, no, sir.
Injunction hearing?
No, sir.
Okay.
He would not hear any of the video, audio, and he wouldn't hear the police officers that we had
Okay.
subpoenaed.
And he ultimately ruled on a legal issue and denied your injunction. Is that correct?
That's correct, yes, sir.
And was that frustrating to you?
Yes, sir.
Did
Very
that
much.
cause you any concerns about whether or not you and your son could rely on the system, including the court system, to protect you, your son, and his family, your family, against the Picayune, Embry, Blake group?
I felt after the injunctions were disallowed, I felt like we were now at the mercy of the street, that we couldn't count on the system to help us anymore. We'd done everything legal we could, and now we have to go back home and play nice, and it started right after that again.
Okay. Now, during the time that between the request for the injunction and the hearing on the injunction, both sides had temporary injunctions in place. Is that correct?
Yes, sir.
And part of that temporary injunction required, at least your perspective, your son to turn over any weapons he may have in his possession to law enforcement. Is that correct?
That's correct.
And did you assist him in doing that?
I assisted him by taking his weapons from him.
Okay. And during the time of the injunction, did you hang on to the weapons?
Did I hang on to him?
Yeah.
Oh, yes, sir.
Okay. And was there ever any effort on his behalf to try and circumvent the injunction and ask you for those weapons back or anything of that nature?
No, sir, he never did.
Okay. And that's consistent with the way you've raised it, right?
Yes, sir.
Now, after the injunction was denied and the prohibition against him possessing firearms is no longer in effect, did you ever return any weapons to him?
Yes, I did.
And when did you do that and why did you do that?
That was the evening of August 29th, 2012, after the injunctions had been denied. I went over to his house. I had weapons in my truck. My son called a police officer, and we had a police officer sitting at the table with us, and he was asked if he could have his weapons back. And the officer said, certainly, you need to be able to protect yourself. And I went out and got his weapons and gave them back to him.
Okay.
You may.
I want to show you with the mark that states 128. Do you recognize that particular exhibit?
Yes, sir, I do.
How do you recognize it? How do you recognize it?
I recognize it because my son had a Beretta Model 92 that he had purchased from somewhere, and we both went out shooting one day. I shot it, he shot my Smith & Wesson, and we passed them back and forth and target practiced with them. And I'm familiar with that gun.
Is that one of the weapons that was returned to him?
Yes, sir.
On the night of the 29th?
Yes, it is.
What was the other weapon that was returned to him on the night of the 29th?
A Ruger nickel-plated 6-inch 357 revolver.
To your knowledge, was that weapon still in the household on September 2nd?
I didn't catch all of that, sir.
To your knowledge, was that weapon, the 357, still in your son's household the night of September 2nd?
To my knowledge, it should have been.
Okay. Now, you were over at your son's house earlier on the evening of September 2nd when his family actually was out to dinner. Is that correct?
Yes, sir.
Did anything occur in terms of interaction with Picayune, Blake, Embry, or any of their gang that evening?
There was no personal interaction between myself and any of them that evening.
Did you observe any activities on their part before your son got there?
Yes, we did. It appeared they were having a party of some kind.
Okay. At that point in time earlier in the meeting, were they directing any of their file toward the house where you were sort of
No,
watching?
no, sir, they weren't.
Now, you were present when your son returned from dinner, is that correct?
Yes, sir.
And did you observe upon his return any change in their behavior?
No, sir, not really.
Okay.
Our car was still parked outside, and we didn't really hear anything.
Okay. Now, at the time around you leaving, did you observe any comments directed toward you and your wife as you were leaving?
I didn't hear any myself, no, sir.
Okay. Now, if the surveillance shows some activities kind of directed, well, let me ask you like this. Your hearing is not the best, is that correct?
That's correct.
Okay. Now, I want to ask you about earlier that day, around 8:16. Did you and your wife have any interaction with Titusville Police Department out or around the area of your son's house?
Yes, we did.
Why did you have that interaction? Was it because of concerns about things that were happening, or
Objection,
what?
lady.
Go ahead. I'll rephrase.
Rephrase.
Why did you have that concern?
We knew that my son and his wife and children would be coming home soon from their anniversary dinner over at her folks. So we went to go to his house and stay there as long as we could while they got in the house safely, and when we could leave. On our going south on Lane Avenue, we passed the northbound or the north loop of Smith Drive, and just past the north loop of Smith Drive on Lane sat a police officer. I pulled up next to him pretty close, and my wife rolled down the window, and we made contact with Officer Roman.
And what did you tell Officer Rowland?
I didn't say much to Officer Roman. It was my wife that talked to her.
Okay. What was the
Objection.
reaction of Officer
Just
Rowland
one-
to
sorry.
that?
Hold on, there's an objection. What? Legal basis?
Hearsay. All of it is hearsay, including the reaction or whatever.
You're saying, you have a reproach?
Attorneys may approach.
As a result of the concerns that you and your wife expressed, Officer Rowland, is there any action?
Again, I object. Relevancy, hearsay.
Overruled. If you know, sir.
I'll repeat. As a result of the concerns that were expressed, Officer Rowland, was any action taken?
After we left Officer Roman's, I drove up in my son's driveway, and we entered his house.
Did you observe any action by Officer Rowland while you were there?
No, sir.
Believe that. That's all.
Cross-examination?
Yes. All right, I wanted to start with, you talked about incidents that you observed. I want to make sure I understand. Now, the first incident that you said you observed was August 5th?
A little quieter, please, sir.
Okay. First incident that you observed at your son's neighborhood about this was August 5th?
Yes, sir.
Right. And your son's sitting on one side of the street
Yes, sir.
and a group of people on the other side of the street?
Yes, sir.
You were present for what had happened before you got there. You were not present.
Oh,
You did
no,
not
no.
see what happened before.
No, sir.
You did not know how your son had acted before you got there.
No, sir, I didn't.
Was your son upset?
Yes.
All right. Were the people across the street upset?
They didn't appear to be as upset as they were upset. I look at upset as something that your demeanor is completely different.
How about angry?
Yes, they were all angry.
All right. That's what I mean by upset. They were angry with each other. Right? Your son was angry with them,
Yes,
and these people were angry with your son.
that's correct.
And your son was angry because he was losing the chicken, right?
At that point, I hadn't heard anything about the chickens
Okay.
when I first showed up.
Now, I think you were talking about incidents that happened to you involving Mr. Peacher, Roger Pecor.
Okay.
And there were two of those, right?
There was, yes, sir. Two of them caused the injunction.
Right. Because you would have put everything that Mr. Peacher did in your petition for an injunction. Would you get the injunction?
Yes, sir, I did.
Put everything in there?
I put both incidents, yes.
Right. And would you agree that the first incident you described, I believe, was April 12th of 2012? Or do you remember?
I don't remember it being the 12th, but I remember it being very, when the injunctions were filed by the other side on Monday the 6th.
I'm talking about the incident.
Which
Well,
is,
let me see if this refreshes your recollection.
okay.
First, just looking at that, you recognize your handwriting? Oh, I'm sorry, August. August 12th. That's your handwriting?
Yes, it is.
Okay. And is the date, the first time you said Mr. Peacher done something to you was on August 12th? Is that what that is, that number?
Yes, that is. That
Okay.
is the 2 dates.
All right, so that, and you wrote this back closer in time to when all this happened, right?
Yes, sir.
All right. Now, you did put in there that from the 12th through the 22nd, he's taunted, picked at, and verbally abused you and your son.
Yes, sir.
Now, were you talking about you, or were in that statement were you actually talking about things you heard from your son? You understand the difference?
You mean things I heard from my son directly to Pecor?
No. No. You mentioned a specific incident on the 12th where Mr. Peacher did something to you.
That must have been the day it rained and the sand washed down and I was out shoveling. That must have been that day.
Okay. Were you working at that time?
Working,
Like employed, or were you?
yes, I was employed, yeah.
So you would be working during the day? In August 12th, 2012?
I was working during the day, yeah.
Okay. Okay. And then the other day you described was August 22nd. And that was the incident where you're walking the dog with your son.
That was that evening, walking the dog.
You were with your son, right?
Yes, sir.
And he threatened you with a baseball bat.
Yes, sir. I got the dates wrong.
Okay. Now, I want to talk to you about law enforcement. How many times were you over at your son's house that you saw law enforcement?
Wow. That's a tough question because I don't recall exactly how many times out of the numerous days I was there that I saw law enforcement.
And I'm just talking about between August 5th and September 2nd.
That's correct. Those were the only days that I went over there, those days to help him walk his dog, or to be with him while he walked it.
Okay.
And I do remember seeing him on occasion, not every day though.
All right. Now, when you went over on September 2nd, you saw an officer right around the corner
Yes, sir.
sitting there?
On August the 2nd, at about
September 2nd.
September 2nd,
Yeah.
about 8 something in the evening.
You said you went over to your son's house before they arrived.
That's correct.
And that you saw an officer parked in a police car a relatively short distance away, did you not?
That's correct.
All right. And that was about what time?
About 8:15, 8, whatever time in the evening.
Okay. Were you aware of, or had you seen law enforcement coming through the neighborhood about every 2 hours?
No, sir.
And you watched that video?
I'm sorry.
You watched your surveillance video that you authenticated?
Yes, sir, I did. As a matter of fact, if you would like me to explain, I went down to the police department and got a copy of the log.
Okay, well, that's not what I'm asking. Because you testified that you watched that video, you watched the whole thing, and I'm interested in the between 9 and 12:40, 9 in the evening till 12:40 the next morning, so from September.
Did I say I was not interested?
No, I didn't. I'm asking you, did you watch that whole segment of time
Yes, sir.
that has been introduced? Now in evidence, as Defense Exhibit 1, this,
Right, yes, sir.
right? And you said you watched all that,
Yes, sir.
right? And did you watch it and see police cars driving by in front of your son's residence twice during the 4 to 5 hours that this would have been played?
Yes, sir, I did.
Okay. So you did see that law enforcement was driving by frequently. I mean, this is a residential neighborhood, right?
Yes, sir.
So you knew they were around. They were there when you drove up, and you saw that they drove by a couple of times during the surveillance video. Did you not?
During those small pieces, yes.
All right, I'm talking 4.5, 5 hours.
In that particular video, yes.
Now, I just wanted to be, and I know that you can't hear me. I want to make sure I understand. Were the children and the dog with you and your wife, or were they with someone else on September 2nd? Children, and I'm talking about your grandchildren.
My grandchildren on the evening of September 2nd were with my son and his wife.
Okay. Your son and his wife didn't go out to dinner without them?
No, they took them with them to have anniversary dinner.
And the dog?
The dog was at their house.
Okay, well, I have a question about that because, you know that same video I just talked with you about? That's the exhibit? Don't we have your granddaughter get the dog out of the car and bringing it into the house?
May have.
So I'm trying to understand, we see you coming from, it looks like from the street, you actually in the house, come out and come in with them? I'm trying to understand if 3 cars didn't drive up, you being one of them, or 2 cars drove up.
Okay.
You understand my question?
Yes, sir.
Because watching the video, your son and your grandson get out of the truck, and your daughter comes from the driveway with the dog in. We see you as well. We see you in that shortly after that.
Okay.
So what's the situation? Are you already there? Did you come with them? Do you remember?
We were already there. We were already there, and I can't really remember if we had the dog on a leash and went down to meet him,
Well, the dog didn't appear to be on a leash at all. It appeared like it
Okay.
got out of the car and kind of gotten away from your daughter a little bit and heading towards the house.
Okay.
Do you recall watching the video and seeing that?
I do, but that didn't really stick in my mind, no, sir.
All right. Now, it wasn't long after they arrived there that you're out by the car, in the truck, spending quite a bit of time whispering to your son. Why were you whispering?
Why was that whispering?
Yeah. Why were you
Probably
whispering?
cautioning him to be careful.
Okay. And why were you whispering? I mean, the microphone, you guys are right there, and that's about the only conversation on the tape that's not picked up as a conversation between you two.
That's because I wanted it to be between him and I. I wanted him to be safe, and I wanted his family to be safe.
Okay. Were you telling him to do anything that night?
No, sir.
Okay. Well, did you tell him to arm himself and set up in a nest over there next to the fence?
No, sir. I did not.
Now, had anything happened, and I just want to be sure, well, let me ask it another way. I think you said on direct examination that you hadn't heard anything other than there was a party going on directed at you, your son's family, that particular evening.
During the time frame we were there, that's correct.
All right. So there wouldn't have been anything for you to tell your son they had done that day.
That's correct.
Right. So was your son upset about the neighbors from anything that had happened that day when you were talking with him?
My son was, he was upset that he felt like that they were going to do something that night.
And he's telling you that at the pickup truck while you're whispering?
We talked both inside the house and out that night before we left. We were there probably just about an hour before we left.
Right. Well, you remember you sat out by that truck kind of looking and talking for a while, didn't you?
Yes, sir.
Now, your son had a trailer parked in that same yard where the truck was, right?
Correct.
And he was getting ready to move out of that house starting the next day, right?
Not the next day, no.
Okay. Is that what that trailer was there for?
That trailer was there for him to start moving when the paperwork went through for the new house.
Okay. All right. So he knew he was moving, right? He knew he was moving out of that house.
He knew that it was coming up, yes.
Okay. Happy about that, wasn't he?
Yes, he was. He was sad at the same time.
Well, he was angry, wasn't he?
No, he was angry that he was having to leave his house just to keep his family safe.
Well, didn't he decide that he was leaving that house as soon as the chickens left? That's when he decided.
As soon as who left?
As soon as the chickens had to go, that's when he started looking for a new house.
No, it isn't. No, sir.
That's when he decided that he was going to leave.
Not from my recollection of conversations with him.
Did you feel that your son had some problems controlling his emotions for this?
Yes.
And how long have you observed him having that issue?
Since about 1991 or 92 when he came home from the Army.
You were with your son when he attacked Mr. Hembry, were you not?
I'm sorry, sir, when he what?
Attacked Mr. Hembry at the courthouse.
Yes, I was. I was right behind him.
Did you know your son would have snapped Mr.
No, I can't perceive I can't predict his motions.
Did your son appear angry that day?
Yes, sir, he did.
And did he appear that he was angry at Mr. Embry?
Yes, sir, that day, that was the day the injunctions were dismissed.
And that was, that Wednesday or Thursday before,
It was the 29th of August.
and this event happened early morning hours of September 3rd, right? For the sheet. Just
That was when that happened, yes.
a few days later.
The injunctions were denied on August the 29th. And August the 29th was when he decided he needed to move away because the activities across the street ramped up to a greater level than they had been all month.
Well, were you there?
Yes. I was there that afternoon.
So we talked about an incident on the 12th and the 22nd, and then the 29th, right?
Okay?
And so were people upset because your son had attacked Mr. Hembry?
What people?
Well, I guess you said everything ramped up. You would agree
Well,
that,
Can I explain it in the way I saw it?
okay? You-
All right.
Well, when did you get there? Let's start there. When did you, that was not the question.
Let's be clear on the question.
I'm going to walk you through this, and you got to explain and tell me. You were at the injunction hearing on the 29th.
Correct?
And then after the injunction hearing,
I did.
and after that attack, where did you go?
We got my son in the car, and my wife and my son and I went to our house.
So you didn't go back to Smith Drive right away, you went over to your residence.
Correct.
And where was Mrs. Woodward? Barbara.
Barbara went to her house with the children.
And that would have been 1960 Smith Drive.
Yes.
Did you go with your son over to 1960 Smith Drive?
Later on, we did. We'd changed clothes.
All right. And so this is after this incident where your son has attacked Mr. Hembry has occurred.
Yes.
So you got over to Smith Drive approximately how long after this attack had occurred?
I don't recall the exact time or even a close time. I know we changed clothes. I don't remember if we even went to eat before we went back over to his house. It was sometime in the afternoon. We left my house, we changed clothes, and we proceeded to his house.
All right. Had you already gotten his guns for him?
To who?
Had you obtained his firearms for him?
He had them somewhere. I gave them to him back on the 29th.
That's what I'm asking you about.
Yeah.
All right. You know, all this is about the 29th. Every question I've asked in the last 5 minutes is about the 29th.
Okay.
After, because the 29th is when your son attacked Mr. Hembry, right?
The 29th in the afternoon.
Right. And so I'm trying to go through that process, and I believe we've gotten to your residence, and your son, the defendant, is there with you,
Right.
correct? And is that when you obtained his Beretta firearm and the Ruger 357 firearm?
No, sir.
Okay. So, did you go back to his residence first? Or did you stay there and he went home without you? What happened?
Let me make sure I'm getting this right.
29.
We left my house, and I'm pretty sure we went back to my son's house, after changing clothes. My son hadn't changed his clothes because he didn't have anything at my house. So we went to his house so that he could go into his house and change from his suit into street clothes. We left and went to supper.
You went to supper.
My wife and I can't remember if we had any family with us or not.
Okay.
We went to supper.
The only person I'm interested in right now is your son, William T. Woodward.
Okay.
Is he left at the house?
As far as I remember, yes.
Okay. All right. When you got to the house, did the neighbors say anything to you?
But yes, they made numerous comments, not only to me, but to my son.
Right. And did they sound like they were angry?
Yes,
And this is after your son has attacked Mr. Hember?
yes.
Did you leave your son at the residence and drive away and go to supper or whatever you had to do?
After we dropped him off, yeah,
Okay. And is we meaning you and your wife?
yes.
When did you bring the guns back? How much later?
Probably, it was dark, around 8:30 or so.
Okay. And so these were his guns anyways, right?
These were his, yes.
When you brought the guns, was law enforcement already there?
Yes, there was a police officer at his house.
After you delivered the guns to him, did you stay or did you leave?
Stood around for another half hour or so and talked with the police officer and my son. And then I left.
Okay. Was the police officer still there when you left?
I think he left before I did, pretty sure.
I don't have any other questions.
Any redirect?
Yes, just briefly. Mr. Woodward, this is that keeps referring to. You observed Gary Henry taunting your son before they had a physical altercation?
Yes, I did.
Is that what provoked your son's response?
Yes, it is, sir.
Sustained.
Did you see the
Granted.
Did you see your son's reaction immediately after Mr. Henry taunted?
Yes.
There was
I was
no
watching.
pause in between that.
I was watching my son. There was no pause.
Now, when you all returned to your son's home, were there similar types of taunts and threats that had been occurring on a regular basis in the preceding days before the 29th?
Yes, sir, there were.
Object unless he has actual knowledge. That's open-ended. Suspicion for personal knowledge, I object.
All right, the same, Mr. Eisminger, if you just make it clear to his knowledge.
Based on your personal observation, were they making the same kind of taunts and threats against you, your son, and your son's family, like they had been consistently since the 5th?
Yes, sir.
Unless it's within his personal knowledge.
I asked the question based on his personal knowledge.
My personal knowledge, I witnessed them running across the yard, making the same taunts, threats that they had been making that month.
Thank you. Nothing more.
Any recross?
I wanted to ask if the taunt that you're referring to that Mr. Henry did to your son was taking his camera out to videotape.
No, he spoke words to him.
So it wasn't him taking his camera out?
No, sir, it was spoken words.
Okay, so you didn't see that? You didn't see him take his camera out?
I saw him with the camera, and I was able to hear the words because he said them loud enough.
Any other questions?
No further question. I would ask that you be released from this subpoena and we will go to.
Okay, thank you, sir. You may step down.
Thank you, ma'am. I'm still under sequestration, right?
Actually, you may remain in the courtroom.
May what?
You may remain in the courtroom.
Oh, thank you. May
I have the attorney's approach, please? All right, ladies and gentlemen, we're going to take a restroom stretch break. If you would leave your notebooks on your chairs, and we'll bring you back in about 10 minutes. Make sure that you follow all of my instructions during our recess. Thank you. All right. Seated.
Here's my next witness is in the courtroom. Do you want me to take the witness chair or wait until the jury?
Let's just wait until the jury comes in, please. Thank you. Please be seated. We are back on the record in case number 2012 CF 55504A, State of Florida versus William Woodward. I'll note the presence of Mr. Woodward at council table with Mr. Eisenmenger and Mr. Robinson, and the presence of Mr. Respis and Mr. Shiner on behalf of the state. Ready to bring the jury back in then? Okay, let's do so. All rise. Jury's present. We are ready. Please be seated. The jury is present in the courtroom once again. And ladies and gentlemen of the jury, did you all follow my instructions during our brief recess?
Yes.
Is anyone aware of any violations of any of my instructions? No. All right. Defense may call its next witness. Good afternoon, ma'am. If you please raise your right hand to be sworn in. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please have a seat over here on the witness stand. If you would please state your full name.
Laveda Jenkins,
Please spell your last name.
Jenkins.
Thank you. You may inquire.
Good afternoon, Ms. Jenkins. What is your current profession?
I am the records supervisor for the Titusville Police Department.
And as such, are you custodian of records that are kept in the regular course of business for the Titusville Police Department?
I am.
Do those include CAD records and reports of calls out to different residences?
They do.
Within the city limits of Titusville?
Correct.
Okay. I want to show you what's been marked.
The attorneys may approach. All right, you may proceed.
I want to show you what's been marked as Defendant's Exhibit E. If you look through that and tell me whether or not that exhibit reflects records that are kept in the regular course of business by the Titusville Police Department, particularly referring to the dates August 5th, 2012 through September 3rd, 2012.
Yes, that's correct.
And those are true and correct copies of the Titusville Police Department.
That is correct.
Enough for the questions of this witness at this time.
Cross-examination.
I would ask that she be excused.
Let me just ask about
Okay, you may proceed.
Now, those are all records that you keep in the records department?
That is correct.
Records?
Mhm.
Okay. Those particular records, are they all authored by employees of the Titusville Police Department?
That is correct.
They are? I still look through there again. Are there statements from civilians in there?
There are.
And are there reports where the officers are relating what others that don't work with the police department have told them?
There are case records, arrest reports. There are statements from witnesses.
Right. So there's a lot of information in those records that is from people outside of your department. It's the civilians that have communicated with your department.
That is correct.
All right. So, but there's some records in there that are internal as well.
Correct.
In there from my agency as well. You guys didn't create that one, did you?
No, sir.
All right. I don't have any other questions.
Redirect.
All of those records revolve around incident reports during those days to the Smith Drive area residents. Is that correct?
That is correct.
All right, thank you. Nothing further.
Okay, any other questions from the state? No? Okay. Thank you, ma'am. You may step down. Thank you. May I have that, please? Turn it to the clerk. Thank you. Defense's next witness.
Your Honor, the defense would call Detective Sarah McCaskey back to the stand.
Okay, Detective Miskowski.
McCaskey.
Yeah, we're all trying to
We'll get it
pronounce
eventually.
it correctly. Good afternoon, ma'am. You're still under oath?
Yes, ma'am.
So you'd retake the witness stand, please.
Detective, welcome back.
Thank you.
You would state your name once again for the record.
Detective Sarah Max Cassie.
You may proceed.
Detective, I wanted to speak with you about some earlier testimony that you gave in this trial. You were discussing the night of entering the Blake residence
That's correct.
while you were on scene on September 3rd.
Yes, sir.
Was the purpose of entering the Blake residence an evidentiary search?
No, sir.
Okay, what were you doing in the Blake residence?
Initially, when I went to the Blake home, it was to interview Carrie Blake and to also see about obtaining video surveillance from her home.
Okay. Was there any video surveillance available at her home?
No, sir.
Was there a camera at her home?
Yes, sir.
Was it recording that evening?
No.
Did you do a thorough sweep for any weapons, firearms, or other evidence in this case?
Not within her home, no.
Did you have the opportunity to enter the Woodward home in the early morning hours of September 3rd, 2012?
Yes, sir.
And what was the purpose of entering the Woodward home?
To interview his wife and to also obtain the video surveillance that we were aware of.
Okay. And you did obtain video evidence. I believe you testified to that earlier.
Yes, sir.
Did you do an evidentiary search of the Woodward home?
No, sir.
Did you personally enter the Hembry home?
No, sir.
Was there a evidentiary search done on the Hembry home, to your knowledge?
Not an evidentiary search, no.
Okay. What was the purpose of any member of your team entering the Hembry home?
Because of the nature of blood evidence that was visible, I know of at least one patrol officer that did go inside the residence to ascertain if there was more blood evidence inside the home or potentially if there was somebody inside that home who had been injured.
Did the patrol officer find any blood in that home?
Not that I'm aware of.
Did they, in fact, stop early to refocus their efforts outside the home?
That's what I was told, yes.
Okay. So, as it relates to the Hembry home, was there any search for weapons, firearms, or anything of the like in the Hembry?
No, sir.
Your Honor, I have no further questions.
Cross-examination. Okay, thank you very much. You may step down. Thank you.
And the witness, to my knowledge, may be excused.
Okay, you may be excused, ma'am. Okay, then you may be subject to recall. Defense's next witness.
Yes. We will call Corporal Joyner.
Corporal Joyner. Good afternoon. If you would step to the podium and please raise your right hand to be sworn in. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God?
Yes, I do.
Please have a seat over here on the witness stand. If you'd please state your full name.
Telly Joyner.
Can you spell your first and last names?
First name is Telly. My last name is spelled Joiner.
Thank you. You may inquire.
Hey, good afternoon, Corporal Joyner.
Good afternoon.
Who do you currently work for?
Excuse me.
Who do you work for?
Work for the Titusville Police Department.
And then back in August and September of 2012, who did you work for?
Titusville Police Department.
Now, during that period of time, did you ever become familiar with William Woodward?
Yes.
How about a man named Gary Hembry?
Yes.
And how about other guy named Roger Pecor?
Yes.
And then another guy named Bruce Timothy Blake.
Yes.
And if you can explain to us, how did you become familiar with those individuals?
We started receiving calls for service out in the neighborhood, reference to a neighbor dispute.
And you said you received calls. Do you remember probably when the first time you responded to a call?
Yes.
And the best of your recollection, when was that?
It was back in the month of August of 2012.
And what was the reason that you were called out?
I was called out. Mr. Hombre called reference to a complaint on the defendant telling his daughter to shut up.
And you went out to the scene and did you do an investigation?
Yes, I went out and spoke with Mr. Hombre, and he explained to me what was told to him about telling the defendant telling his daughter to shut up. He told me his complaint, and I went over and talked to the defendant in reference to his story, his side.
So now, when you went out to that location, that was it was Smith Drive?
Yes.
Now, what did you see when you first got there?
I don't recall what I saw. I remember the complainant coming up to me and after arriving on scene.
Was anybody else outside?
I don't recall who all was out there when I arrived.
Okay. Fair enough. So you spoke with Mr. Hembry, correct?
Correct.
And then did you speak with anybody else?
Yes.
And who was that?
I spoke with William.
Mr. Woodward?
Yes.
And what did Mr. Woodward tell you?
Sustained.
Approach your honor.
Attorneys may approach.
Now, besides speaking with Mr. Woodward, did you do any other investigation?
Well, I spoke with both parties on the complaint that I was out there for, and they both gave me their side as to what occurred prior to my arrival.
And did you do anything else besides speaking with just Mr. Hembry and Mr. Woodward?
Other than take both parties' statement, I don't recall doing anything else at that time.
Did you write a report?
Correct?
You think if you saw the report, it would refresh your memory about what happened?
Yes.
Madam, may I approach the witness?
You may.
All right. Thank you, Corbett. Do you kind of remember now what happened?
Yes, somewhat.
So other than speaking with the parties, did you do any other investigation?
Spoke with a neighbor. Came up and told us a little bit about what was going on.
Did he describe to you what he had seen?
Yes.
And did he explain to you any concerns that he had?
It's a yes or no question. Overruled. You can answer, sir.
Yes, he did.
And what were those concerns?
Sustained.
Oh, let me ask you something. So so now, other than what Mr. Crow had said to you, did you do any other investigation?
Not that I recall.
Did you think if you could read your report, would it refresh your recollection?
There was no other investigation other than what I was called out there for. I did speak to Mr. Woodward's wife.
And did you receive anything from Mr. Woodward's wife?
Yes.
And what was that?
letter of events that occurred between Mr. Woodward and Mr. Humphrey.
Now, based on this incident in your investigation, what steps did you take?
I took the letter she wrote and attached it with the report, and followed up with a state attorney on some mediation for both parties.
Now, you were saying you followed up with the state attorney for mediation. What was that specifically? Who did you call?
I contacted State Attorney Phil Archer.
And why did you call Phil Archer?
To assist with some type of resolution or mediation for the parties.
And was there a resolution?
Not that I can recall.
Now, the best of your recollection, was there any effort to ever set up a mediation?
I don't recall. I didn't follow up with them other than that phone call.
But you never followed up after that phone call?
As far as what was going to be done after that day, I don't recall.
Now, following this incident, did you ever have to respond again to Smith Drive?
Yes.
And when was that?
It was during the month of August.
And was that towards the beginning or the end of August?
I don't recall the dates.
So you say if you don't recall the dates, was it, you have no recollections? You don't know if it was towards the end or?
I don't know if it was towards the end, but it was, don't recall the dates.
So now, was it after the incident we just spoke about?
Yes.
Now, are you aware of an injunction hearing that happened in this case?
Yes.
Can you place the next call in relation to the injunction hearing? Was it before it? Was it after it?
It was after this call here.
So it was after this call, when we just spoke about. The second call, though, where was it in relation to the injunction hearing?
I don't recall, sir.
Now, are you familiar with a CAD report?
Yes.
You think if you could look at it, it would refresh your recollection?
Yes.
Can I approach, Your Honor?
You may.
Now, Corporal, does that refresh your recollection about what happened?
Somewhat, yes.
And what can you tell me about that incident?
That CAD report is a reflection of routine property check in that area.
And why were you making routine property checks?
Major at the time saw the need due to the ongoing issues between both parties and what was taking place between the both parties as far as the, I guess there were some psychological concerns on Mr. Woodward's behalf. So we wanted to do property checks through that area, show our presence.
And do you know what a pre-plan is?
Excuse me?
A pre-plan?
Correct. Yes.
What is a pre-plan?
It's pre-planned. The call is pre-planned, put in the system, and it pops up every hour that is requested for us to respond to that area.
Now, did you respond? I'm sorry, let me take a step back. What was the name of the major you spoke about just a minute ago?
At the time, it's Major Butler.
So were there any other incidents that you responded to?
We responded to a junction hearing, but we weren't, we didn't testify for that.
Well, tell us what happened.
It was a result of all that was going on, and we advised both parties during the time we responded out there to seek an injunction on the other party.
Now, on whose behalf were you there? So what, did somebody subpoena you?
No, I don't believe we're subpoenaed. We're just requested by one of the superiors at the time.
But you never gave testimony.
No.
Why did you not give any testimony?
Overruled. You can answer.
They didn't need us to.
Okay. So now let me move on. After the injunction hearing, did you ever respond to Smith Drive again before this incident?
Not that I can recall.
So if I'll show you a CAD report, that might refresh your recollection?
Yeah.
Approach your witness, Your Honor.
You may.
You remember that?
Yes, that was one of the many times I was out there. So.
What can you tell us about this incident? Well, specifically, what date did this incident occur?
I believe it's September 1st.
And what happened?
Again, another argument between the parties.
And you responded?
Yes.
And when you got there, what did you see?
I don't recall who was there and what the scene was.
Okay. So on this day or any other day, did you ever obtain any video from the Woodwards?
Not that I can recall.
Now, I want to go back to the injunction hearing that you were at. That was in relation to this case, is that correct?
Yes.
And other than yourself, what other law enforcement officers were there?
Mainly the officers that had contact with the parties during the time of the incidents.
And how many law enforcement officers do you think were there?
About 3 or 4.
So do you know specifically who was there?
Not all, no.
Well, whoever you remember, can you tell us?
Yes, Sergeant House, Officer Nelson, myself. Not sure if any others were there or not.
About Commander Butler, was he there?
Possible.
Now, were there ever any incidents when you were at the courthouse between you or other law enforcement officers in either the Coors, the Hembrys, or the Blakes?
As far as the injunction goes?
Yes, at the injunction, yes, sir.
Yes, they were inside the injunction hearing.
And was there any incidences or any words exchanged or any issues?
Not that I can recall.
Have a moment, Your Honor.
You may.
So now, at the injunction hearing, didn't Major Butler, order the Titusville officers there to not get involved with the pissing match?
Sustained.
That's all I have. Thank you.
Cross-examination?
The exhibits that you refresh his memory with, please. Good afternoon, Corporal Joyner.
Good afternoon.
How are you? The first time that you responded to incidents involving the Woodwards and the Hembrys was the 13th of August, 2012?
Not sure if that's the first time, but that is the first time took a report.
Okay, that's the first one that you spoke about, at least today.
Correct.
Okay. And on that particular day, do you recall when you received the call?
Yes.
What time did you receive the call?
The time, I'm not sure what time.
Let me ask you this. When the call came in, were you immediately dispatched there?
Yes.
And
Responded.
did you respond immediately?
Correct.
Do you recall the time, how long it took you to respond once you received the call?
No, sir.
Was it with less than 10 minutes?
I would have to review the CAD report to give you a definite time.
Let me ask you about the next time that you responded, which I believe would be, that we talked about, would have been the 28th of August. Is that right?
I believe that's one of the days that I did respond.
Okay. And when you received that call, did you respond immediately?
Because I don't remember if it was an immediate response or not.
Okay. Is there something that would refresh your memory?
Sure.
The CAD call?
Yeah.
I approached?
You may.
Is your memory refreshed?
Yes.
Do you recall the time the call came in?
10:57.
Do you recall the time you were dispatched?
But the call came in, I was dispatched at 10:57, I'm sorry.
When did the call come in?
10:53.
Okay. And when did you respond?
10:57.
So the call came in at 10:53, you were there by 10:57?
I was dispatched at 10:57, arrived at 10:59.
59, okay. And then on the 28th, you responded, is that right? Well, the 28th, you had a compliance response, right? Is that the day that you had where you were responding because it was an automatic for routine patrols?
I'll have to look at the CAD.
Can I approach the witness?
You may.
Do you recall?
The one you just gave me is for the 31st.
Oh, that's the 31st?
Correct.
Well, I may have read the date wrong. Oh, I read the printed date, I'm sorry. For the 31st of August,
Correct.
right? Was that a routine check?
Yes.
Okay, and that was already in the system that you would respond every so many hours
Yes.
because of the parties involved?
Correct.
And because you were told something about psychological and Mr. Woodward may be armed, is that true?
Possible weapons in the house.
Mr. Woodward's house.
Correct.
And then you responded immediately upon being dispatched to that area, is that true?
For 31st,
Yes.
I didn't immediately respond there, but it was a couple minutes time frame.
So within a few minutes?
Correct.
Okay. And so for those type of things, your system is already updated, right? And then, so information would come to you that's in the system that will automatically dispatch the closest responding unit to that particular area. If
We'll
you're
pop up for our dispatcher to send a unit in that area.
okay. And if you're free, you respond.
Correct.
And that particular day, it was in the system for dispatch to notify a road patrol officer to respond to the area of Smith and Lane, right?
Correct.
And you did that.
Yes.
In fact, anytime you, as a Titusville Police Department corporal, were requested to respond to that area or any incidents involving the Woodwards or the Hembrys, you responded.
Yes.
This is for the incident, or on the incident on September 1st. Do you recall when the call came in and when you responded?
No, I don't. I would have to look at the time.
Refresh your memory if you looked at it.
Yes.
Do you recall?
Yes.
At what time did you respond?
16:48 hours.
And what time did the call come in?
Correction, 16:48 was the time the call came in. I responded at 16:50.
16:50. And when did you get on scene?
16:53.
During your investigations, isn't it true that it became apparent to you each time you responded and that you were involved in an investigation involving the Woodwards and the Hembrys, that this was going both sides across the street?
Attorneys may approach.
Did you talk to both sides of the street every time you were there? Is that right?
Just, yes.
Okay. And did you instruct both sides of the streets to stop, basically?
Yes.
Anything else? Nothing further.
Any redirect?
Just briefly to clarify one issue. May I approach a witness, Your Honor?
You may.
Corporal, on the cross, you were questioned about some language at the bottom of the CAD report on the August 31st, 2012 CAD report. Do you know where that language came from?
What's the language?
May I approach, Your Honor?
You may approach the witness.
Yes.
And where does it come from?
It was explained to me by Mr. Woodward and his wife.
And is that something that was put on all CAD reports?
That's a pre-planned CAD report, so it would show up every time.
Okay, thank you.
Okay. Any recross? Okay, thank you very much, sir.
Thank you.
You may step down. Before we call the next witness, may I have the attorney's approach for just a moment, please? So Major Butler, please. Good afternoon, sir. If you'd step to the podium and please raise your right hand to be sworn in. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
I do.
All right, please have a seat over here on the witness stand. You would please state your full name.
David Butler.
You may inquire.
Thank you. Chief Butler, what is your current role in the legal community?
I'm sorry?
What is your current employment?
I'm the chief of police at the Indian Harbor Beach Police Department.
I'd like to take you back to August, September time frame. Who are you working for then? No, I'm sorry, 2012.
Okay.
It would have been helpful if I given you a year, right?
The Titusville Police Department.
Okay. And what was your rank and assignment there?
I was, if I remember correctly, I was a major or a commander. They changed the rank structure a little bit, but it was equal, basically the same. And I was in charge of the patrol division.
Okay. Now, were you responsible for any pre-plans specifically involving the area at or around 1960 Smith Drive South?
When you say pre-planned calls for service, is what we're talking about?
Right.
Yes, I was.
Okay. Can you kind of explain to the jury what a pre-plan is and why you would set something like that up?
A pre-planned call for service is something that would pop up on our CAD system. We have what's called a CAD system, where we dispatch officers to calls for service. A pre-planned call would be something that would pop up routinely, so it reminds the officers to go out there and do a check. In this case, I ordered a pre-planned call for service to do a property check. That's a drive-through of the area, make sure everything was going well on the area of Smith Drive.
Now, were you responsible for the language in the pre-plan indicating that Mr. Woodward had psychological disorder and may have weapons in the house?
To some degree, I would say yes, but the verbatim, no, I didn't give them something to write and then type it in verbatim. So as a general rule, they probably summarize what I said.
Your department had received any number of complaints regarding the Hembrys, the Picures, and the Blakes activities directed toward the Woodwards, had they not?
We did, yes.
Including the fact that they had threatened them and had weapons of themselves, correct? Not offer for the truth of the matter asserted, but their actions.
Sustain. Rephrase.
Had you not received similar information about Pickior, Blake, and Hembry,
I'm sorry, sir, similar information to what?
in terms of whether or not they may have weapons in their home.
I don't recall if I ever received that information. I couldn't tell you for sure.
Okay. Was there some reason why none of your pre-plans mentioned Hembry, Pickior, or Blake, even though they were involved in this ongoing dispute?
No.
Now, did you yourself ever obtain any video from the Woodwards?
I do not recall that, no.
Do you recall your department being offered video surveillance of the Hembry, Pickior, and Blake activities directed toward Mr. Woodward?
I do recall hearing something that there was video surveillance on the Woodward property, and that he would offer to show the officers that responded to the scenes those videos, yes.
And isn't, in fact, none of your officers ever recovered any of that video until after the shooting?
I don't know. I couldn't tell you that.
Did you ever instruct any of your officers to get any of this video when you heard about these offers of video surveillance?
No.
Now, you were actually present among the officers at the injunction hearing between these parties, isn't that true?
I was.
And isn't it a fact that there was an incident at that where...
I haven't heard the whole question, but
Well, let me finish the question.
please do.
Did you not advise the officers not to get into a, quote, pissing contest with the Hembrys, Pickiors, and Blakes regarding their attitude and activity toward your officers that were present?
Sustained.
Did you yourself make any sort of comment toward that to your officers?
I'm sorry, sir, one more time. Couple different things. Can you repeat that? I'm sorry.
Okay. Did you instruct your officers not to get involved in a pissing contest with the Hembrys, Pickiors, and Blakes? It would not be hearsay.
Okay. May I have the attorney's approach, please?
Did you observe antagonistic attitudes by Hembry, Pickior, and Blake towards your officers?
I'm having a hard time hearing you. Did I observe? Did I? It's okay.
Did you personally absorb antagonistic attitudes directed toward you and your officers by those three people, Pickior, Blake, Hembry?
At the injunction hearing is what we're talking about?
Yes.
Not specifically which behavior they were doing about. Remember, this was many years ago. I do remember it was very tense. It was a very tense situation in the waiting area and while we're waiting for the hearing. But specifically what they did, I couldn't tell you exactly what they did or who said what or anything like that. I took no notes. It was 5, 6, 7 years ago.
Do you recall giving any instructions to your officers as to how to respond to their attitude?
My instruction, not specifically, but I know what I would have said.
I don't want you to speculate.
I can't specifically remember what I said to the officers.
Did you respond to any of the calls in this area?
No.
Did you conduct any briefings or any, I'm not sure of the terminology, so correct me if I don't use it, but, you know, like morning briefings or afternoon briefings where you, bring the group together, advise them of possible trouble situations, things to be on the lookout, things of that nature?
No.
Did you ever instruct Corporal Joyner to contact the state attorney's office regarding trying to get them involved in some sort of mediation process?
Specifically, I don't, but that I could see myself doing that, yes. That would be reasonable.
Did the state attorney's office ever respond to that and try and set up a mediation?
I couldn't respond to that, no.
Cross-examination? All right, thank you, sir. You may step down. Detective Cabrera, please. Good afternoon. If you please step to the podium, and please raise your right hand to be sworn in. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God?
Yes, ma'am.
Please have a seat over here on the witness stand.
Thank you, ma'am.
You would please state your full name.
Detective Jessica Edens Cabrera,
Please spell your last name.
Cabrera.
Thank you. You may inquire.
Thank you. Detective Cabrera, back in August and September of 2012, you were primarily known as Detective Edens. Is that correct?
Yes, sir.
Congratulations on change status. I just had a lot of weddings in the last 5 years.
Yes, sir.
I want to ask you specifically about what's been marked as Defendant Exhibit I. Well, I'm showing that to the state. Do you recall responding to the Holmes Regional Center at any time during around September 2nd or 3rd of 2012?
Yes, sir, I did.
And what was the purpose that you responded to Holmes?
I was assigned to respond to Holmes Medical Center because one of the victims of the shooting were there, Mr. Pecor. When I arrived, I met with Holmes Regional Medical Center staff and a security guard from Holmes Regional Medical Center.
Okay. And do you recall the date that you responded?
I believe it was the 3rd at around 4 in the morning.
Okay. And while you were there, did you obtain any property of Mr. Pecor's?
Yes, sir.
If I may approach?
You may.
I want to show you a copy of your receipt, photographs of a couple of items. Do you recognize those 3 items? I want to apologize. It's already been marked as Defendant Exhibit I.
Is the item number 1 the property receipt, sir?
It's a composite exhibit, all 3 of those things.
Okay. Yes, I recognize all 3 of these things.
Okay. And are those the pictures of the items, 2 of the things that you recovered from Mr. Pecor's property?
Yes, I actually received it from Holmes Regional Medical Center Security. It was already collected for me at that time from Robert Reichenbach, I believe is his name, the security officer.
Okay. I would offer for identification.
I object to it coming in as a composite. I don't object to the 2 images coming
All right, may I have the attorney's approach, please, with the exhibit? All right, so Defense Exhibit I then will be number 2 in evidence. Any objection to the publication?
No.
Okay, you may.
And while they're looking at that, that's all the questions I have.
Thank you.
It's okay.
Correct.
Okay.
Before cross-examination, let the publication
Okay.
proceed. Thank you.
Detective, I wanted to ask, did you ever see Mr. Pecor or Mr. Peacher at the hospital when you collected these things?
Yes, I did see him.
All right. Did you see the items removed from his person?
No, sir.
So you don't have any personal knowledge as to where these things came from or even if they did come from, right?
No, sir. I received those from the security guard.
So you're relying on somebody else for the information you put in your report, right? You didn't,
Yes, sir.
You didn't do it yourself. You didn't see it happen,
Correct.
right? And did Mr. Peacher die while you were at the hospital? Was he pronounced?
No, sir.
Okay. So this was, you had a property receipt that had things, and there was 3 pages of property receipts?
Not from me, I don't believe so, sir. May I see? I do recall this one page, and then there was a second page that had, I believe, the CD on it as an item.
Okay. So your report references, or at least the report says 1 of 3. Is that not accurate?
The third page was probably the property receipt from Holmes Regional Medical Center that was added.
Okay.
But my property receipt was not.
Okay. So this has everything but the CD on it?
To my knowledge, yes, sir.
Fine. Did you take these pictures?
Yes, sir, I did.
So that's what the CD would have been?
Yes, sir. I took photos of those items, the other items that I collected, and then some photos of Mr. Peacher.
Redirect?
And that's pretty much standard operating procedure for you to go and recover from the hospital items that are taken from someone who's taken to the hospital for treatment, right?
Yes, sir.
Nothing unusual about the way you obtained that property?
No, sir.
And that property was reported to come from Mr. Piccio?
Yes.
Had Mr. Piccior gone into surgery before you got there? Or?
I can't answer that question. I'm not sure. When I arrived, he was unconscious. He had been bandaged. I know that he at least had an MRI done because I viewed the MRI. Other than that, I can't tell you what medical staff did.
Any other questions?
Sounds fairly obvious to he was alive.
Yes, sir.
Okay. No other questions? Thank you, ma'am. You may step down.
Thank you.
Yes, the attorneys may approach. All right, ladies and gentlemen, it's a good stopping point for the evening, so I'm going to ask that you leave the notebooks on the chairs. We'll lock them up for the evening, and let me give you your recess instruction. We will recess until tomorrow morning at 8:50 a.m. so that we can start promptly at 9 o'clock. During this break, you must continue to abide by the rules governing your service as a juror. Specifically, you are not to discuss the case among yourselves. This means no discussions about the case whatsoever, no matter where you are, including the deliberation room. Do not discuss this case with anyone else or allow anyone to discuss it in your presence. Do not speak to the attorneys, parties, or witnesses about anything. Also, do not conduct any research regarding any matters concerning this case. You must also avoid reading any newspaper headlines and articles relating to this trial or its participants, and you are to avoid seeing or hearing any television, radio, or internet or social media comments about this trial, should there be any. So with that, with the exception of Juror 139, I would ask that you remain, sir, but everyone else may be excused, and we'll see you tomorrow morning at 8:50. Thank you. All right. Please be seated. All right, juror number 139, it was brought to my attention from the court deputy that you needed to leave on Friday at 4 and you needed to be in Orlando by 5. Is that accurate?
Yes, ma'am.
Okay. Can you tell us what the issue is as to you being able to leave early on Friday?
So my son has an event over there that starts at 5:30. I thought I'd be able to get someone to to get him over there. It's turned out that that's not possible. If I can get out at 4, I know I can get him there. But I think
So you need to take him over to Orlando, is that what you're indicating?
Yes, ma'am.
May I ask what the event is?
Basketball.
Basketball game?
Yes, ma'am.
All right, does the state wish to inquire any further? Defense? All right, may I have the attorney's approach for just a moment, please? All right, juror number 139, we will do our best to accommodate you in your schedule on Friday. While I cannot guarantee that you will be able to be out of here by 4 o'clock, like I said, we'll do our best to work around that schedule. and we'll have a better indication perhaps tomorrow, and perhaps be able to give you also a better indication for your schedule on Friday. I would advise, however, that you try to make alternate arrangements, if possible, for this event on Friday. But like I said, we will do our best, and we'll let you know a little bit more updates, okay? All right. At this time, you may be excused. We'll see you tomorrow morning, sir. Thank you. All rise. Please be seated. All right. As far as the request of the defense to offer testimony via 980322, state or defense have any other authority or case law that you'd like to present in regards to the issue?
Appropriate use of the prior testimony, that there is no constitutional concern in this regard because the state has no constitutional rights, only procedural rights, and that it's necessary given the witness's prior inability to recall certain things that he's already testified to at a prior hearing.
And how does that relate to Ms. Carrie Blake?
Well, I could certainly understand the court perhaps wanting us to try with Ms. Carrie Blake before we go through this same procedure. We bring it to the court's attention because it's something we anticipate that we need to do in this case, because we're expecting a very similar reaction. The court feels that we need to call her first, see what we're able to get out on direct examination, and then publish it only after trying. We can certainly do that. I would note, I don't think the rule contemplates that. It's simply whether or not they've testified previously and whether or not there was a adequate opportunity for the opposing counsel to develop their testimony through either direct or cross. It would certainly streamline the process if we can publish her prior testimony, but if we need to try first, we're certainly willing to do that. Obviously, as it relates to Mr. Bruce Timothy Blake, we know from his testimony earlier in this trial that his memory is impaired at this point.
And how does the defense respond to the issue if the court was inclined to grant the request as far as reading the transcript as opposed to having the actual digital recording so that the jurors could potentially observe demeanor, credibility, and weigh those issues?
It's very difficult to do that because it doesn't show. So we saw it shows me.
Your Honor, first, we don't have a copy of the digital recording. We only have the transcript that we had previously ordered for appeal in this case. Secondly, if the recording that's available is similar to the one that we've already seen from Mr. Woodward, you're going to see the back of the witness's head as they testify, so we won't have much opportunity to see demeanor except to hear it. Finally...
Inflections, tone of voice, things like that.
Certainly. The question and answer that we've prepared, I think, is quite clear and would streamline the process. To play the entire testimony, again, this is a hearing that took multiple days previously. This particular testimony is of a nature in which the witness's recollection is refreshed with the recording. The witness then either acknowledges or doesn't acknowledge a statement that was heard on the recording. Sometimes it has to be played back 2 or 3 times before the witness will acknowledge either hearing it or not. So what we've identified and what we would intend to publish are the times in which the witness, by way of either a question or their own admission, identifies hearing a statement and then either attributes that statement to themselves, another person, or simply can't attribute it to somebody but nevertheless acknowledges that that statement was said that particular evening. That's why we think this way would streamline the issue. And the state could certainly publish any other portion of the transcript they think is relevant in that regard. To play the entire video will be similar to what we've already gone through with Mr. Woodward, and that's just not the way we'd prefer to present our case. But if that's the way the court's most comfortable, we do feel this evidence is necessary.
All right, and one final question for the defense. If I understood correctly, you were asking me to allow this under that exception, and you're asking me to allow you to simply read certain questions and responses, but not the entire transcript. So it's what the defense has deemed what they believe to be relevant to the case?
That's our position, yes, Your Honor.
Okay. All right. All right, state have any further authority or case law to cite?
I have somebody working on it.
Okay,
They believe Earhart indicates that Abreu applies to civil and criminal cases. I want to think about this some more, but here's kind of where I'm at on this thing. I think if a witness is actually called to testify, and they've had the transcript and they actually use the transcript, they've had the ability to impeach the witness, they've had an ability to confront him with his prior testimony, and so anything that, that, in my view, the transcript should be used under 9612, I think it is, for impeachment, extrinsic impeachment, if the predicate has been laid. This is a situation where somebody has actually testified. So I don't think that that's appropriate. And so I believe that if you're going to use it as former testimony, it should be, since the rule contemplates everybody's had an opportunity to talk to the witness, that the jury should hear the entire testimony for the context of the testimony as long, I mean, that's their testimony. It's not a piece of testimony. If we're going to do this, then I think it all comes in, not pieces.
all right, any other case law you would cite at this time, Mr. Vespis?
The only case that I'm aware of on this issue right now is the Abreu case that I provided to you.
Your Honor, if I could respond briefly to the state's argument.
Just one moment. I'm sorry, you said Avery?
What now?
Did you say the Avery case?
I believe it was ABRU, wasn't it? Hold on, I have it.
State cited the Grabo versus
Grabo,
Department of
that's
Health case,
Yeah,
816 Southern 2nd 701.
that's it.
Is there another case that,
I mean, it cites to Earhart cites to another case where the court granted civil parties a new trial because they admitted that and they found that violative because of violation of due process or whatever, because it was procedural. But they were citing to the other case. How do you pronounce it? Grabo. So I'm, and at least Earhart says it applies to both civil and criminal, but I want to reflect on that and think that through before I take a final position on that, Judge. So I'd really like to have some time to think about it.
all right, defense, have anything to add to the record?
Yes, Your Honor. I understand the state would prefer that we use this as impeachment evidence, but this rule contemplates it being available as substantive evidence in furtherance of our defense, and that's why it's so important that we be allowed to present it in this way, because the refreshing recollection / impeachment, with the refreshing recollection, we got some of what we needed from the witness. Impeachment, we got very little of what we needed from the witness, but we're looking for the substantive value of the evidence, which is what this rule contemplates, is it being admitted as substantive evidence where we can then argue to the jury that that in fact did occur, as opposed to you can't believe Mr. Blake because he said something different at this prior hearing. And so that's why it's important that we be allowed to present this evidence.
All right, I'll give the state an opportunity to respond briefly tomorrow as well, but I will advise the defense to make sure that you have witnesses available and ready to proceed in the morning when we resume at 9 a.m. And then I'll make my ruling in regards to whether the defense may present the evidence in that fashion.
Yes,
Is
Your
there
Honor.
anything else we need to address before we recess for the evening?
Yeah, I do have witnesses available, so I can look around, however the court rules.
Okay, very good. Anything further from the state? Okay, thank you all very much. Have a good evening. We'll be in recess until tomorrow at 9 a.m.